So I think we could start. Leonora, would you like to say a few words of introduction?
Okay, thank you, Armando. So, good morning to everyone. I'm Leonora Barbiani, Secretary General of the Italian-Russian Chamber of Commerce, and I'm pleased to welcome you today to the first of a series of webinars planned by the law firm Berti, Jacchia, a company member of our Chamber of Commerce. All of us have personally experienced the changes and the revolution that the virus has taken in our personal, social, and professional lives. For this reason, I believe that it's even more important to value transformations as an opportunity and focus our attention on them. Actually, the program planned by the law firm Berti Jacchia is devoted to legislative changes occurred because of COVID-19. Today we are launching the first seminar, which is on labor and IP law. And for us, Italian-Russian Chamber of Commerce is the last webinar of 2020. Then I invite you to put in your agenda the second online meeting on the 21st of January, when the Berti Jacchia is going to focus the attention on another crucial issue during COVID-19 time. That is to say, corporate, commercial and dispute resolutions. Last but not least, on the 4th of February, the series end with the webinars Tax and Administrative Law. So today I'm not having a speech. Therefore, if I can, Armando, I wanted to introduce all the speakers. That is to say, Armando Ambrosio, resident partner of the Berti Jacchia. Then Mr. Igor Brazhevsky, associate of the Berti Jacchia. He is going to have a speech on reduction of costs for personnel at the time of COVID-19. And then Alicia Pestriakova, associate of the Berti Jacchia, and she is going to have a speech about COVID-19 regulation and the changes in the IP area. At the end, another speech by Mr. Igor Brazhevsky, remote employment at the time of COVID-19. So what can I say? Enjoy the webinar, the first webinar today, and let's see on the 21st of January and the 4th of February of 2021, and have a nice day.
Thank you, Leonora. My name is Armando Ambrosio. I'm the resident partner of the Berti Jacchia Moscow office, even though actually I'm not in Moscow right now because I'm speaking from Italy, just essentially for reasons connected to COVID. We basically would like to thank the Chamber of Commerce for joining us in this initiative. And I would like to explain why we decided to do this program, which Leonora very clearly presented. The idea was that we live in the era of information. There is always plenty of information on the internet, and COVID has made this situation even worse because you need to be updated day by day in order to understand what are the news in terms of legislation, regulation, and so on. I've seen that all law firms have tried to catch up with this problem of giving to their clients and contacts all up-to-date information as soon as possible. Sometimes it's not so easy to do that, and sometimes you make also mistakes. So it's always a balance between being the first who gives the information and being at the same time those who provide the reliable information. As I said before, we live in an era of information, but the real problems now is the reliability of information and organization of information, because plenty of information is given to us from different sources, but we need to select it and establish who are the leaders, who are the people who are reliable in giving the information, At the same time, I think that enterprises and companies have a special need, the one that they need to have all the information organized, selected and ordered and systematized in a very simple way so that they can easily have access to this information without going different sources and understanding what's going on right now. So after all the, let's say, chaotic legislation that we had in all countries, Italy, Russia, but everywhere in the world, due to COVID, now we think that it's time to reflect a little bit, to stop and to make a summary of what's happened and try also to understand what are the trends of the legislation, because when it starts, well, all starts, it's only a chaos. You don't understand much, you just try to read one or the other. You have listened that someone is giving you some information, but you don't know actually what's going on right now. So the idea is that let's stop for a minute, let's collect all the information which has been given in a very, very fast way. Now we are doing, our effort is to put everything together and give you a whole framework, which I think is essential for companies who are in these difficult times operating on the Russian market, but on any market, Italian, whatever, European market. So that was the idea behind our program. That's why we decided to focus on areas. So we decided to select the main areas which are critical for enterprises, like labor law, like IP, like commercial law, like tax and incentives, administrative law. But we also thought that mediation could be also a very good tool for the enterprises to try to minimize the cost connected to litigation in these difficult times. So we selected these areas and we've decided to make a short presentation on each of these. My colleagues who are experts in these different fields will be, each of them will be responsible for giving you the presentation. Today, we will concentrate, as Leonora was saying, on labor law and intellectual property. Then we have, as we said before, two other appointments. One in January, on the 21st of January, on commercial law and dispute resolution. And the second one on the 4th of February, concerning tax, incentives for enterprises and administrative law. I think that these are very crucial and appointments for the enterprises who wish to continue to work in an effective way on the Russian market. So I think I said everything, and I pass the word to my colleagues. Just one recommendation. We will have one presentation first from Igor Brazhevsky concerning the reduction of cost in labor matters. Then we will have a second presentation on IP, and then we go back to the remote employment issue, which is a very, let's say, hot topic in this day due to the new federal law. I would prefer that you concentrate the questions at the end of each presentation. So there will be a presentation, then a range of the question and answers. And then we start with the second presentation and we go on, instead of giving all the questions just in the middle of the presentation or at the end of the presentation. So I think that we will try to concentrate. Of course, you can make your questions through the chat box. We will collect them and let's say, ask the question to our speakers at the end of their presentation. Thank you for, let's say, your attention, and I give the floor to Igor Brazhevsky. Please, Igor.
Thank you, Armando. Good morning to everyone. Thank you for joining the webinar. And I will start my presentation on the first topic, which is also quite hot, considering the current difficult situation. This is a reduction of costs for personnel at the time of COVID-19. So just 1 second, I will open my presentation. So is the presentation visible?
No, Igor. Unfortunately, we cannot see it.
Sorry. Just 1 second.
Okay, now it's visible.
So is it okay now?
Yes.
Okay. So when we consider the issue with reduction of costs, first of all, we could use one of the two possible options. Option A or option 1 is the option which is not connected with termination of employees. Another option is the option connected with termination of employees. Of course, for both parties, for employee and for employer, the option A seems more preferable, and we could say that it is more widespread, and of course it is generally accepted by employees rather than option B, because they continue the employment relationships, they continue to receive salary, and of course they generally agree with the option A. Of course, it is not very convenient to for the employer to agree with the employee about the option A, and we will speak in details how this can be reached and what are the main difficulties. If we consider the option which is not connected with termination of employment agreement, the first option is to decrease the working time that the employee performs. Decrease of working time could lead to the following decrease of salary, because the salary should be paid proportionally to the actual working time. And if we decrease working time, as a result, the salary of employees could decrease. And in this case, of course, this could reduce the costs for personnel. The decrease of working time was quite popular in the crisis period of 2008, and it is also still popular in the current period with pandemic and also with the crisis period. And a decrease of working time always requires the agreement with the employees. So if we need, let's say, to decrease working time, since the working time is one of the compulsory clauses of the employment agreement, we should reach with the employee a mutual agreement, and we should sign an addendum to the employment contract. Important is that decrease of working time should be for a certain time period, because this can help to reach an agreement with the employees, because employees will understand that this is just a temporary measure and not a constant measure. And when the situation improves, the working time could be restored, and employees will receive the same salary as in the past. This is the option when we have an agreement with the employees, but there could be a situation that employees do not agree with the decrease of working time. What could be done in this case? In this case, we have only the option with so-called unilateral change of labor contract clauses. Generally speaking, we should say that this is quite a difficult option, because Russian legislation is quite difficult in this relation. We have Article 74 of the Russian Labor Code, where it is mentioned that such change of labor contract clauses is only possible when there are some organizational and technological changes in the organization. These changes should be proved by the required documentation. For instance, one of such changes could be restructuring in the company when some of the departments are closed and there is some kind of delegation of duties between different departments. And all this may lead to the necessity to change the clauses of the labor contract with the employees. What is important here to mention is that there is a lot of court practice that confirms that economic reasons would not be used for changing the contract unilaterally. So the economic reasons could be served only as the consequence of the organizational technological changes. So the crisis, for instance, could not be served as a ground for changing the contract without the agreement with the employee. Unilateral change of labor contracts is also quite an unpopular measure because it requires a prior written notice of the employees, which is 2 months, and there is a quite high risk of further challenging this change of labor contract by the employees. And due to contradictory court practice that we have, it is, let's say, quite difficult to say whether the decision of the court will be in favor of the employer or in favor of employee. Another option that we could consider is provision of paid and unpaid leave. What is essential to mention here? When we provide the paid leave to the employees, it is, of course, always an initiative from the employee, because the employee should sign a required application for provision of vacation. So it should be agreed with the employee in advance, and the employee should, let's say, be in agreement with this. And in case we provide the employee with paid leave, we should pay to the employee an average monthly salary, which is less than the actual salary the employee receives when he is working. Therefore, such paid leave could be also used as a tool to reduce costs for personnel. And another reason is that, according to Russian legislation, every year the employee is provided by 28 days of vacation. This is a minimum provided by the law. Of course, the agreement could provide, employment agreement could provide more days, but generally it's 28 days. And every year this number of days are accumulated. So if the employee does not use his vacation days, the number of days is increasing every year. And the provision of paid leave in current situation could decrease the balance of unused vacation days. So as a result, it could be also a kind of reduction of costs for the employer. If we are talking about unpaid leave, it is very important to understand that we cannot force the employee to use it, and this should be only the initiative from the employee to use this unpaid leave. And what is currently existing in practice is that employees would like to have some kind of cross obligation from the side of the employer if they use such kind of unpaid leave, because for a certain time period when they use unpaid leave, they are not receiving any salary, and of course it's not a good option for the employees. Therefore, they would like to have some obligation from the side of the employer. For instance, there could be a kind of clause in the employment contract about additional severance benefit in case of termination, or a clause that does not allow termination within the specific time period. So that could be used by the employees as some guarantee for them in case of further termination of the contract. Also, we could say that such options as decrease of bonus payments or decrease of social benefits are also used in practice quite often. By social benefits, we understand here for instance, medical insurance, corporate fitness, increased per diems in case of business trips, or additional payments for sickness period. And it is important here that before such decrease, we should clearly review the employment contract, internal labor documentation, because quite often the bonus payments, social benefits especially, are structured in different way. It can be structured as obligation or as the right of the employer. So if this is an obligation, we should definitely provide it. And if it's the right of the employer, it could be some kind of discretion from the employer to provide it. So it's important to review how it is structured in the documentation. Another important issue is that if the social benefits are clearly stated in the employment contract, we can only change it bilaterally. So it means that we need to reach an agreement with the employee and to sign an addendum to the employment contract. If the employee disagrees with this, the only option would be to proceed with unilateral decrease. And in this relation, we need to refer to Article 74, which I already mentioned in the previous slide, which is quite difficult for implementation. So our recommendation here is not to use, if possible, unilateral decrease, because it's quite difficult and there is a quite contradictory court practice in this relation. And the best recommendation here would be not to structure in details the provision of social benefits in the employment contract, but rather to have only a reference in the employment contract to some internal labor documentation. For instance, we could mention in the employment contract that medical insurance is provided in the amount stipulated by the regulations, some kind of internal labor regulations or regulations on payment. And in this case, if we need to change the amount of insurance, we don't need to reach an agreement with every employee, but we need just to change the regulations, and the regulations and the new provisions will be enforced. Also, if we consider the options which are not connected with termination of employees, the construction with outsourcing or outstaffing could be one of the options. If we use outsourcing, we could, for instance, delegate some functions to specialized consulting companies. For instance, HR functions or accounting could be delegated to some specialized companies. As a result, there will be a decrease of job duties of the employees in the company, and if such decrease takes place, we could decrease the salary. Outstaffing could be also one of the options if we need for a certain time period to hire employees. We could refer to private employment agency that will hire the employees, and the organization will use the workforce for a certain time period when it is needed, rather than hire employees without involvement of such employment agency. And also distant or remote employment, how it is mentioned in Russian legislation, could be one of the options for reduction of costs. The topic about distant remote employment we will speak in details in the next presentation, but just briefly, we could say that such kind of employment could decrease significantly office expenses, because if the employees are working remotely, the company does not need to rent any office, and of course it could be a significant decrease of expenses. Also, additional termination grounds could be used in case of distant remote employment. However, here we should mention that this is only possible until the 1st of January 2021, and we'll speak later on in details about this. But we also need to understand that distant remote employment could lead to some additional expenses for electronic signature. the rules about electronic signature we'll also speak later on. So basically, these are the most, let's say, popular and widespread options for reduction of costs if we are not going to terminate employees. However, in some cases, this is the only option to reduce the cost to terminate employees. And in this case, we should refer to the second option, or option B. When we are considering option B, the most important construction which is used in crisis period is staff redundancy. It could be even more popular to use if, for instance, we have in the company some kind of so-called low performance, so employees with less productivity, and in order to avoid to use option A for all employees, for instance, if we need to decrease salary for all employees, we could rather choose to the option about staff redundancy and to terminate just the employees with less productivity, so-called low performance. And in some case, it could be even the best option. Of course, we should understand that staff redundancy is quite a difficult procedure. It is regulated by the Russian legislation quite significantly, and important is to fulfill all the procedures and all the steps. Otherwise, it could be further challenged by the employees in the court, and the employee could be reinstated in job. So what is important for staff redundancy is, first of all, a prior written notification of employees, which is normally 2 months. Another important issue is the offer of vacant positions. By vacant positions, we understand here the positions that are not occupied by employees, but are existing in the staff table of the organization. And such positions should be offered to the employees that are due to termination for staff redundancy. Another important issue is preemptive right. The construction of preemptive right is applicable only in case we are terminating some of the employees that occupy the same position. For instance, in the company we have the position of sales manager, and in this position we have 5 employees. But we don't need to terminate all 5 employees, we need just to terminate 3 of them. And in this case, we need to consider their preemptive right, which means that the priority should be given to those employees who have higher productivity and higher qualification. So this means that we should compare all these 5 employees and should choose those who let's say do not have such preemptive right. Another category which we have in Russian legislation is so-called protected categories. This is a categories of employees who cannot be terminated in case of staff redundancy. This, for example, are employees with children, pregnant women, employees with children under certain, employees with children under certain age. According to the Russian legislation, these categories of employees could not be terminated in any case in case of staff redundancy. So it's not possible. So we should identify such categories, and we cannot apply staff redundancy in this case. And the last one is severance benefit, which should be provided to the employees. And normally it could be up to 5 average monthly salaries. So if we are planning a staff redundancy, we should understand that quite significant amount should be paid to the employees, and we should reserve this amount in order to fulfill all the obligations. The key issues which are referred to staff redundancy are the following. Staff redundancy shall be real. Here we mean that it means that if we are terminating the employees due to staff redundancy, it means that we do not need these employees for the company, and we cannot hire in 1-2 months other employees for the same position and just solve the issue with the current employees. And if we terminating, it means that there is no need in these employees. Another important issue is that all the steps of the procedure should be duly fulfilled. If any of the step is not fulfilled, it means that the termination could be challenged by the employees, and it is probably the court could restore the employee in the position. So we should take into consideration that all the steps mentioned in the law and all the procedures shall be duly fulfilled. When we are facing with staff redundancy, we should understand that there could be some problematic issues in practice. One of such issues is notification of employees. If the employees are working in the office, it's basically not a problem. However, there are, of course, some formalities to be taken into consideration. But the most important is how to notify employees when they are working remotely. So this is especially important in the current situation with pandemic, when there are a lot of employees that are working remotely. And the employer should consider different options of organization such kind of notification. For instance, through the courier service, through the delivery by post, or any other possibility that could ensure the due delivery of the notification to the employee. And what is even more important, we need to have a documentary proof that the notification was done and the employee signed the notification. So in the current situation, it could be quite problematic. What else should be considered? That not all vacant positions are offered to the employees. When we discussed the staff redundancy, we mentioned the fact that offer of vacant positions should be done to the employees, and it is important that such offer of vacant positions should be done within the whole period, starting from notification of the employees about termination and until the final termination date, which is more or less about 2 months. And within all this period, we should offer the vacant positions to the employees. Otherwise, it could be further challenged by the employee, and the termination could be deemed invalid. Another important issue is notification of trade union. However, it is not applicable to all employers, only to the employees whether the employees, whether are employees and that are in a trade union, they are members of trade union. But if such a situation occur, we need to consider also the need of receiving the notification from the side of trade union. And the last issue is the situation with sickness of employee on the date of termination. So when we start the staff redundancy procedure, we notify the employee 2 months in advance about subsequent termination, and in the notification there should be a final termination date. And quite often in practice there are such situations where employees are on a sick leave on the termination date, and here it's not a significant problem, but we need to understand that if the employee is on a sick leave, we could not terminate him, and the date of termination should be postponed, and there should be a subsequent termination as soon as the employee returns to work after the sickness period. Considering the staff redundancy, I think it is clear that it is quite a difficult procedure, which requires a lot of formalities, a lot of steps, and we should understand that sometimes it could be not so popular to be used by the employers, and what other alternative can be used if we need to terminate employees. One of the options here could be reaching a mutual termination agreement with the employee. We should consider that this option could be even more widespread because it requires less formalities, and it is also more attractive for the employee because when the employee is terminated, he receives his labor book with a record about the ground for termination. And of course, if the employee receives the labor book with a record about staff redundancy, his future, let's say, employer could raise some issues about this. If there is a record about termination due to mutual agreement, basically it is considered as more neutral rather than staff redundancy. So the mutual termination agreement is, of course, more attractive for the employee. Another advantage of this construction is that it is less burdensome for the employer. It requires less formalities, less procedures, and it is also achieving the final result, termination of the employees. However, it is important that to exercise this option, we need to reach a real mutual agreement with the employee. And the most important clause in reaching the mutual agreement is, of course, the amount of severance benefit, because Russian legislation does not provide any minimum or maximum amount. And this is always a negotiation between both sides, between employer and employee. And in practice, there are different cases. Some employees would like to have 2-3 monthly salaries or 5 salaries, which could be considered as more or less reasonable amount, especially provided to the fact that in case of staff redundancy, as we described before, it could be up to 5 monthly salaries. So for mutual termination agreement, 5 monthly salaries could be quite a reasonable amount. However, in practice, there are situations when employees request even 12 months of severance benefit or even 24 months. So, of course, such kind of amount could be not possible for the employees in different cases. And in this aspect, mutual termination agreement could not be used as an alternative. So basically, I've reviewed all the critical issues, all the main aspects connected with reduction of costs, and if there are any questions, I'm ready to answer.
Yep. Thank you, Igor. So questions can be raised through our chat, or you always can raise your hand in the chat so that I can give you the word and you can speak lively. So thank you, Igor, for, let's say, explaining to us the legal framework, especially the practical options that are available to the enterprises who are doing business in Russia in terms of reduction of cost with the use of termination or without the use of termination. My question was, what do you see as a trend in the market in terms of our clients, but also in terms of, let's say, the general public, how the companies are, let's say, facing these difficult times, and which options they are preferred in the first place, and which one are their preference?
Well, we could say that the preferable option is the option without termination of employees, of course, and because to terminate employees in Russia, it is quite a difficult story, and because Russian legislation protects the employees quite significantly, and employers do not prefer to use, let's say, the option with termination unless there are no other alternatives. But if we consider the option without termination, we should say that the option with decrease of working time and proportional decrease of salary, I think, is the most widespread. Also, decrease of social benefits, decrease of bonus payments, and I think that, yes, this is the most widespread in practice.
Okay, thank you.